welcome to Crime in Court. This is the 1996 Menendez brothers retrial. We are reading through the transcript. Unfortunately, we don't have video. And today we are going to go over the state's. The state is going to rest. So this is like the final part of their case. We have Dr. Roger McCarthy still on the stand for a little bit, and we will have Detective Zoeller on the stand shortly to just briefly to finish out the case for the state, and then we'll get to dive into the defense's case and look at their experts and compare and contrast them from the first trial and see really that this is what I'm looking forward to the most is how the defense's case changes based on the different rulings from Judge Weisberg and allowing and disallowing certain experts and certain evidence to come in regarding the abuse. So we are going to compare and contrast going forward, especially with the defense's case, which I think is a little more interesting than the state's. Although this time around, their case didn't change as much, I would say. Their case was pretty much similar, but they tried to pile on, I think, with like um, the girlfriend, Jamie Pisarcik, and uh, what's his face? He's got the really weird name, Eslaminia or Eslamania, whatever his name is. He also, they try to monopolize on, the dishonesty of the brothers when, yes, okay, you can be dishonest and not a killer, and you could have been dishonest about the crimes to get yourself out of the crimes. That doesn't mean that you're lying about the things that happened in that home. And they really tried to play out um, the fact that Lyle made it up, that it was just made up out of whole cloth based on this movie and all that. So I think, that did kind of change a little bit in the state's prosecution is that they always tried to deny the abuse, but this time around I think they were just a little more prepared to do so. Well, anyways, so before we get into the state's case, you may or may not have already heard this, but there was some breaking news this weekend, and I'm going to read you a tweet or an X post whatever it's called, an X post that I posted this weekend regarding that announcement. So, over the weekend, it was announced that there's been some action on the habeas petition that the brothers filed years ago. So I'm going to give you a little bit of a background on that petition and where it's been, why it's been sitting in kind of limbo, and why I think the judge made a ruling in this. And then we're going to read the ruling, and then we will get into the state's case. So bear with me as we dive into this. Please hit that like button if you haven't already done so. All right, so this is my post from the weekend. It says, breaking news, California judge has ruled in favor of the Menendez brothers' habeas corpus petition. The habeas petition citing evidence of abuse on May 3rd, 2023. So just FYI, a habeas petition is like an appeal to a higher court saying we need relief due to our conviction, our sentencing, misconduct in our case, whatever it might be, new evidence that has come in. So that is kind of where the habeas comes in. That's, with the higher court, superior court, or yeah, so superior, supreme, whatever. We're at the superior level, I believe. So like Los Angeles Superior Court. Um, or California, I should say, California Superior Court, not Los Angeles, the state Superior Court. I don't know what I'm rambling on about. Hope you hope you get it. All right. So it goes county court, then state court. So this would be state Superior Court. All right. So anywho, on May 3rd, 2023, Erik and Lyle Menendez's legal team filed a habeas corpus petition arguing that the brothers' convictions and life without parole sentences were unconstitutional due to the emergence of two key pieces of evidence that were not available during their trials, their 93 and 96 trials. So this is new evidence. We've talked about this kind of at length on my channel. So one of the things was a 1989 letter from Erik to his cousin Andy Cano, who did testify in both of the trials. At the time of the trial, they didn't remember or know that this letter existed. They didn't, I'm sure it wasn't even on their minds that this letter even happened. It did happen, though, according to the legal team and who found it. It was in 19, they can best determine that it was 1988, so it would have been the summer before the homicides. So, or not the the year before the homicides. So anyway, um, in this letter, Erik details things about Jose coming into his room at night and how he can't stand it, and how Jose has gained all this weight and he's just, he's disgusting to him, and like things like that. So it's very much referencing the abuse and the trauma left behind from that abuse. He worries about Jose coming into his room at night. That's pretty suggestive of what was going on in that house. So that was one piece of evidence that we didn't have. It was later discovered after Andy Cano passed away, and journalist, author Rob Rand, who wrote one of the best books, I think, out there about the Menendez trial. He is the one that found the letter after the brothers had already been sentenced and convicted and all that, well after that. So he found that it is now evidence in their habeas. And the second piece of new evidence that came in was a sworn affidavit by Roy Rosello, who was a member of the boy band Menudo back in the 1880s, 1980s, 90s. So around that time. This was the 90s. All right, so he claims in this affidavit that he was drugged and sexually abused by Jose Menendez, and this indicates a pattern of abuse, which we know is very likely. He abused his wife, his children, and it's not unreasonable to think that there were others. So, but even besides Roy Rosello. So that is Roy, Lyle, and Erik, closer to what they look like now. Because those are more recent pictures. All right, so why are we just getting an answer now? We've had the DA's tactic all along has just been delay, delay, delay. Originally, it was with George Gascon's team, but they also kicked the can down the road because they didn't want to deal with it. They did do the resentencing petition and all that, but they never wanted to respond to the habeas because in some way it's like admitting that your office was wrong, even though it wasn't his office. It was, the DA's before him. It was Gil Garcetti was the DA at the time. But George Gascon, who was the predecessor of the current DA, Nathan Hochman, he also kicked the can down the road. So, as you can see here, since the petition was filed in 2023, the DA's office has requested and received multiple extensions, which include June, September, and November of 2023, as well as January, March, April, July, August, and September of 2024. Their latest request was filed on November 26, 2024, in which the DA requested a delay until December 20th to provide his response, and that was also allowed. The DA has yet to file anything in response to the habeas other than, extensions. So we can, at least this is, I surmised, assumed that the reason we're seeing a response now is because of the DA's lack of response. So this could have likely entered it into a judicial review phase where the judge on the case, Judge William Ryan, was then able to evaluate the petition and the evidence independently without, having to hear both sides. Basically, he was just able to look at it, review it. And that is what I believe is likely what happened. If you guys are interested on this ex post I have here, you can go and Google or go to my Google Drive here and it will, um, you can view the letter from Erik. You can read that. You can also read the affidavit from Roy Rosello, and you can read in full all the exhibits, and the full petition is on in that link there. All right, so what happened this weekend is we learned that over 2 years after this habeas was filed, Judge Ryan made a ruling on the long awaited petition. In his ruling, not only did he validate the new evidence that was cited, so basically he said, yes, this evidence that I'm seeing, I find it credible. He's saying it is credible evidence, this letter from Erik to Andy and this affidavit from Roy Rosello, I find it credible despite the fact that Nathan Hochman has been saying it is not credible, they're all liars, we're the only ones that are truth tellers type of deal. So the judge says, no, 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 I find it credible. But also, the judge says that there is a potential for this evidence to overturn the convictions had the jury heard it. So he's saying, yes, I rule in favor of the brothers. I I think that so far I need to know what what the prosecutor has to refute this because so far I'm inclined to deal or to rule in favor of the brothers. So Judge Ryan has ordered the DA to show cause within 30 days. Basically, this means he needs to show some kind of legal justification, whatever justification he has to say, no, Roy Rosello is not truthful or this letter is not real. So I don't know how he's going to prove those things. So it's going to be a little difficult for him, which is good for the brothers. So finally, what does all this mean for the brothers specifically? Under California law and U.S. Supreme Court precedent, new evidence that undermines the confidence in the verdict can justify reopening the case if it suggests a miscarriage of justice. So anything that means justice wasn't served in this case could mean we can reopen it, we can look at it again and reinvestigate or whatever the case may be, decide to overturn a conviction if that's what they do. So by ordering the Los Angeles County DA to quote unquote show cause within 30 days, this would be approximately, August 12th, although now I know that the order from the judge was dated August 7th, so maybe it's more aligned with August 7th that they need to provide their response. So he's asking them, so by ordering them to give their response, the court has now shifted the burden to the prosecution. So the burden was with the defense to prove, like, hey, we have reason to believe that something, something wasn't right in her case. And the judge has ruled, yes, I believe you and I find you credible. So now the burden is with the prosecution and he has to say, well, Roy Rosello's lying, or which he has said straight out before, basically, and that the letter is not real. He's basically said that it's just too late. That was his reasoning before. But he's gonna have to give a better reason than that now. So this ruling does not immediately overturn the conviction, so don't get your hopes up, kind of, but don't get them too up because we're not there yet. But this does open the possibility for post-conviction relief. So there's something that they might do is vacate the convictions altogether. They could grant a new trial, which I find highly unlikely, or they could reduce the charges from first degree murder to manslaughter, which I find most likely. if they apply a self-defense argument, which they were denied in their second trial. So I think this is most likely what's going to happen, which will then allow them probably, immediate parole because of the fact that, changing from first degree to manslaughter, their sentence should be immediately reduced, which means they've already done more than enough time and they should be out immediately, which I think is the most likely thing that will happen in this case. So, all in all, this is really, really, really good news. We don't know what's happening yet, but this is a giant step forward for justice for Erik and Lyle Menendez. And we are starting to see, um, things progress, which is very, very exciting. Really quick, I wanted to read this is a very, very short article from TMZ. I thought it sheds a little bit of light onto what we were just talking about. So this was yesterday, an article from yesterday titled "Judge to Prosecutors: Why Shouldn't I Throw Out the Murder Convictions?" This is a big deal. The judge in the Menendez case says that the new evidence unearthed in the murder case, if true, makes a compelling case to throw out their convictions, which would mean that they could be released without even having to go through the parole board hearing, which is awesome, which is actually scheduled next month, August 20th and 21st. So if this happens first, since August 7th, August 12th, whenever his specific 30 days is up, that's going to happen first before the parole board hearing. So if the judge could potentially change their uh, sentencing to manslaughter and they could be released before they even have parole, which would be wild. So, according to new court documents obtained by TMZ, LA County Superior Court Judge uh, William C. Ryan has received the two pieces of new evidence. First letter, the the first piece. Hold on, sorry, I had a frog in my throat. Kind of still. So the first piece was the letter. The second piece was the affidavit. Um, this is the part where I wanted to get to. So this declaration, according to the Menendez attorney Mark Garagos, shows that the prosecution was off base in characterizing Jose as not the kind of man who would abuse his children. Also, the judge in the murder trial severely limited testimony about alleged sexual abuse. Garagos has filed legal documents arguing this new evidence would have changed the outcome of the trial, so the convictions. Oh, my page just jumped. So the convictions did it again, should be overturned. Judge Ryan said that the new documents, Judge Ryan said in the new docs, sorry, to the prosecutor to show cause. This page keeps jumping and it's really annoying me. So, translation, the judge says the Menendez brothers have made their case to toss their convictions, and now the prosecutors have to rebut that within 30 days or the murder conviction could be overturned. They have their parole board hearing in August. So this is exciting. They have multiple avenues to freedom here that it's like we're just getting closer and closer. It's happening this year. I can feel it. It's happening. So that is that. Let's read this very quickly, or as quickly as we can here. So, Superior Court of California, County of Los Angeles. Um, the people, California, Eric, Erik Menendez. We don't have Lyle. Maybe there's a separate one that's identical to this, probably. So this is from the Honorable Judge Ryan. And this is here again, this makes me believe that because there was no action in this case, it went into judicial review. So it says this matter is called for judicial action. On May 3rd, 2023, petitioners Erik and Lyle Menendez filed the instant habeas petition alleging the discovery of two new pieces of evidence that would have more likely than not changed the outcome of their second trial, at which they were convicted of murdering their parents, Kitty and Jose. We have a footnote. Because the petitioners are both victims, share the same last name, each will be subsequently referred to by their first name. Okay, that was a footnote. First, petitioners present a letter from Erik Menendez to Andy Cano, which petitioners allege corroborates Cano's testimony and the essay allegations that petitioners made at trial. Second, petitioners present a declaration of Roy Rosello, a member of the popular 1980s band named Menudo, admitting that he was AR'd by and orally copulated by Jose in 1983 or 1984. Petitioners allege that this new admission counters the prosecution's argument that Jose was restrained and forgiving, which we've seen that as we've read through the state's case. They've tried to make him seem like he was just a really. They can't even try to make him seem like a good father, but the best they have is like people saying that he was not a violent man or not that kind of man that would abuse his children. Those, that's character opinion that you don't know because you didn't see him behind closed doors, so it shouldn't have come in, and that was the picture that they've been trying to paint. On October 24th, 2025, respondent filed a motion requesting the recall and resentencing of petitioners pursuant to the section code, stating that the brothers, quote, have demonstrated exceptional post-conviction conduct and that, quote, they no longer present a public safety risk pursuant to the penal code such that their current sentence is no longer in furtherance of justice. Ultimately, on May 13th, 2025, petitioners were resentenced to 25 years to life on all three counts. However, count two's term is to run consecutive to count one, and count three's term is stayed. Meanwhile, respondent filed an informal response to the instant petition on February 21st, 2025. Respondent argues that, so the respondent is the DA's office. Respondent argues that both the Cano letter and the Rosello declaration do not constitute as new evidence under the definition of Section 1473, subdivision whatever, and that the Rosello declaration is inadmissible and immaterial and lacks credibility, again stating basically Roy Rosello is a liar. Respondent also argues that the Cano letter is procedurally barred as untimely. Well, that's the whole point of a habeas is that it didn't come, we didn't know that it was there. We didn't know of its existence. We forgot about it. We didn't know it hadn't been found until years later. But yet he's saying it was untimely. So that makes no sense to me. It's like arguing, yeah, it's illogical arguments. But anyways, so that was his argument as to why it shouldn't come in. Petitioners filed their reply to the informal response on May 22nd, 2025, reasserting their claims for relief and countering the assertion that the claims are untimely. So, of course, you can say it's untimely, fine, yes, it is untimely, but the whole purpose of a habeas is that you've found new evidence. It's new. That's why it's new. N-E-W, new. Anyways, order to show cause. This is the good part. Assuming the truth of the petitioner's factual allegations. So he's like, I'm taking them at face value. I'm assuming it all as fact. Assuming the truth of the petitioner's factual allegations, as the court must, at this stage of the proceeding, the court finds petitioner has made prima facie showing that he is entitled to habeas corpus relief. Accordingly, respondent is ordered to show cause. So DA Nathan Hochman is ordered to show cause if he has any cause. You're ordered to show cause why the relief requested should not be granted. Respondent is to file a return on the petition within 30 days of service of this order. Petitioner may file a traverse or denial 30 days after filing and service of the return. Unless further hearing is ordered, the matter will be deemed submitted upon receipt of petitioner's traverse or denial or after the expiration of the time for filing the traverse or denial. Not exactly sure what that sentence all means, but basically he's got the 30 days. It's kind of the ball's in his court for the 30 days, I believe, although I think the petitioner can appeal that, it seems. I'm not exactly sure how that all works, but they've got 30 days. The clerk is ordered to serve a copy of this order upon Mark Garagos and Cliff Gardner, the attorneys for the brothers, and upon Deputy District Attorney Seth Cormick as counsel for the respondent, the people of the state. So he's actually doing the filing, Seth Cormack, who is in Nathan Hochman's office. So that was that. This is good news. This is basically stating I believe the brothers. I take them at face value. I find what they have submitted to be credible. And at this point in time, your arguments, Nathan Huckman, are not valid to me. And I think that we need to reevaluate because, um, yeah, they're saying that something that you're claiming is new evidence and stating, oh, well, it's untimely. That's illogical. That's that's like a little kid saying it, a parent saying it's bedtime, and the little boy's like, no, it's not. Like, okay, but I'm the parent, and that's kind of how this works. Like, this is the time. I have the proof. This is new. This is a new time. Now your bedtime. But anyways, yeah, so it's just very illogical, some of the arguments that they're making. And I think that we need, oops, I'm trying to do two things at once here. I think that it's very appropriate that the judge stepped in because we haven't had any answers since. It's been over 2 years at this point. And I'm glad that we're finally seeing some movement on that. All right. So that is my very long announcement, but I wanted to get through that for you to give you the explanation, the background, and everything. So let us get started now. We're going to begin with where we left off last for the state is recross. Mr. Gessler, the state just finished its redirect. So now we're going to go into Mr. Gessler for Lyle Menendez. He's going to be doing his recross. Whoops, I just screwed up. He's going to be doing his recross examination. Um, Here we go. I can't think and talk at the same time. All right, so recross examination, Mr. Gessler says, Dr. McCarthy, if you take the buckshot shots at 13 you have computed here, there's an enormous number of possibilities as to show those can be in order, can't there? And then he provides no audible response. He says, let me ask you this. If there's 10 of any kind of random events, there are millions of possibilities as to which could be first, which could be fifth, which could be 10th, aren't there? 10 factual, I think, is the calculation. What? And 10, oh, factorial. Factorial. What is factorial? And 10 factorial means you take 10 times 9 times 8 times, you take, excuse me, 10 Factorial means you take 10 times 9 times 8 times 7 times 6 and so on to calculate the possibilities. Is that correct? That is the precise calculation of 10 events respecting order without regard to order. And that comes up in this case to approximately 3.6 million, doesn't it? I'd have to I'd have to turn on my calculator, but it's a high number. Well, how long would it take you to calculate? If this calculator has a factorial function, I can do it instantly. There's a brief pause in the proceedings. It doesn't. Just a moment. He calculates, yeah, 3.6 million. So about right. 3.62880 times 10th to the 6th. So we're talking in the range of 3.6 million plus 3,600,000 plus possibilities. Yes, 3,600,280 800. Wait, what? I don't know. You see the number. 3,600,000 628,800. Yeah, that's how you say it. Sorry. Brain's not functioning apparently with numbers. And then have you told this jury the one sequence that you have happened that you feel happened, the one sequence that you feel happened to the elimination of the other 3,599 odd thousand? Not exactly. As I've indicated at various points, there are places where I can't pin down the shot order. You could shuffle these shots for perhaps a dozen or two different sequences. I don't think it would materially affect my conclusions about the geometry of the shot, but where I can pin the ordering of precise physical evidence, I've tried to so indicate. So you've taken from 3.6 million to about 24. I'd hate to say 24, but I haven't sat down and calculated it. It's a lot fewer than 3.6 million. Because of your ordering of the shots, in other words? Well, ordering of the shots and the physical evidence which constrains some of the shots and not others. Well, how many buckshot did you say there is per round of buckshot? 27. And even if some have 26 and some have 28, by your calculation, 27 is certainly the average that you'd find. Oh, use 27. Yeah. All right. We'll use 27. With the 10 rounds of buckshot that were used here, how many pellets does that give you to work with? A total of 270. Now, in one of those shots, you have come up with a count of, by x-ray, of at least 27 buckshot. That's your first shot, right? Yes, I believe the x-ray, reasonably interpreted, shows 27. Or a full round, in other words. Yes. And how many other shots have you found in a full round? That is 27 buckshot by x-ray to confirm your shot calculation. The first shot was the only one that what I'm going to say is backstopped sufficiently in my mind to catch all 27, but there's no others where I would represent to you that I believe come up with a 27 count. And that's assuming that you're correct, that the 27 count you have are all coming from your first shot, isn't it? Yes. Now, of the 270 buckshot that apparently were fired this night, how many were recovered for you to work with by X-ray by the police by any means? I couldn't tell you. Less than a third? Conceivably, I just haven't attempted to count. The only one you attempted to count was the backstop or shot number 1. Just the opposite. It's the only one where I had x-rays and the alignment between the body parts, and no one dug all the shot out of that poor tree, there. Hmm? Let's forget the tree. Let's go to the 9 buckshot rounds, all or part of which hit Mr. or Mrs. Menendez or both. of those 9 rounds, you're working with about a third of the buckshot, would you say? I haven't sat down and tried to correlate all the evidence envelopes, and so I can't tell you. So some of your shots, you can account for 5 buckshot, 10 buckshot, or you just don't know. On a shot basis, I can give you a rough approximation which we can account for. Shot 2 to the back of the head, there were 11 buck. Well, what happened to the other 16? There were 2 exit defects at the corner identified above the right ear. So it's your opinion all of 16 went out of those exit defects, or do you know? Obviously, I don't know. And other shots, the same is true, isn't it? You don't know what happened to the buckshot that are not accounted for by X-ray. Not matched to shot, that is correct. Thank you. Nothing further. Court says, Ms. Abramson, she says, I need to move some exhibits around for a minute, Your Honor. What I'd like to do is add some sub numbers because I'd like to stay back at the podium. The court says, okay. Court says, okay. Ms. Abramson says to 301, which is also called 1B. Starting on the left, there are 2 photographs. I'm going to mark the one above A, the one below B, and down the center, C, D, and E, and the single photograph on the right, F. While I'm here, Your Honor, I'm going to do the same for 295. Excuse me. There are 2 photographs down the left, and I'm going to mark them A, B, and C. There are 4 in the center, D, E, and F, and G, and 3 on the right, H, and I, and J. All right. So now that she's marked those, recross examination begins. And she asks, Dr. McCarthy, calling your attention to 301C, the top photograph in the middle of the top chart. Do you see that? Yes. And does it appear to be a photograph taken at the coroner's office that shows the coroner probing wound number 3, as he calls it, to Mr. Menendez? Yes, that is consistent with the appearance of the photograph. And in that photograph, does it appear that the probe is being inserted in the lateral aspect of the upper arm, the back? Yes, it looks like the probe disappears there. I can't see what he's pointing to. And is it your understanding that when coroners are using a probe for demonstration purposes for a photograph, they put the probe into the entry wound? Objection calls for speculation. I think this was asked and answered previously. The court sustains that. Ms. Abramson goes on. Now, you don't see him sticking that probe into the individual pellet defects into the antecubital fossa to open that arm, do you? Objection, irrelevant. Overruled. The witness says no. They've all, as you pointed out previously, been eliminated by the surgical work. What you're seeing on the medial aspect, the inside of the arm, is a dissected area? Yes. Is that right? I believe so. And in the September 95 written amendment, Dr. Golden clearly labels the wound that he has the probe in that photograph as the entry, and the other side of it, which you can see in 295 photographs A and B, the large defect, as the exit, correct? I'm uncomfortable making that inference. It doesn't look to me like the probe is even remotely at the right angle to be an entry on that back of the arm. But could he have the tip of that pointing to that area? Perhaps, although I can't tell you from the photograph. So you want to quibble over whether the probe is fully in the wound or pointing to the wound. Objection, argumentative, sustained. My question was, in the 95 amendment, he clearly indicates, does he not, that the entry wound for number 3 is a large, ragged defect on the back, lateral aspect of the upper arm, and the exit is a large defect on the medial aspect, or the inner surface of the right arm, correct? Correct. Now, you indicated in response to questioning from Mr. Khan that when Dr. Golden amended that report, he deleted references that previously appeared to forearm defects on the dorsal aspect of the right forearm. Yes. And do you assume because he deleted the paragraph that described that the wounds disappeared? No, because his confidence in them, obviously, the wounds were whatever the wounds were. That answer again, I'm so sick of it. They were what they were. It is what it is. Like, so tired of him saying that. You're looking right at them, aren't you? If you're looking at 301, paragraph D, the one in the center. No, we're looking at the photograph of what ultimately we can't see when the body is cleaned. In other words, we see these spots here when the body is clean, there's no view of that arm that captures those supposed defects. However, that's precisely where Dr. Golden described the forearm defect in the report before he deleted that particular paragraph, didn't he? He earlier had mention of these, and after examining the photograph, he revised his report and deleted any mention of them. You don't know if he deleted it on purpose or by accident, do you? I do not. And you deleted them all the way through your reconstruction. You've never referred to those wounds, have you? That is correct. Any view of the cleaned up body fails to show them. There is a very legitimate question whether they're there at all. Assuming they are, and you just ignored them, you just don't account for them in the reconstruction of yours. I haven't attempted to account for them. No view, once the body is clean, shows them. Is that yes, you didn't account for them? That was the question. I did not. Now, did you and your associate at failure analysis, well, strike that. You recall, we've previously talked about the fact that you gave discovery to the defense in this case by way of the program that contained the views that you were going to show for your reconstruction during or being on a CD-ROM disc, correct? Or tape, yes, or tape. And on the disc and or tape, you also included various diagrams, body chart diagrams, correct? Whatever we had, we prepared some diagrams. And you haven't used those diagrams here in your testimony, is that right? I have used them. Have you showed them to the rest of us during your testimony? No, I don't recollect doing so, but I'll be glad to. That's what I've been looking for the last 10 minutes. Miss Abramson says, I have two diagrams. I'd like to have them marked next in order. One of them, although they are hole punched, one of them is called Joseph Menendez External Injuries. I'd like to mark that. The court says 311. She says 311, and the other one is marked Mary Menendez External Injuries. I'd like to mark that as 312. Are these diagrams that failure analysis prepared? Yes, of our attempt to characterize the coroner's original findings. And was a decision made in consultation with you not to use them because they are so inaccurate? No, they reflect the original autopsy, which was inaccurate. So, I mean, I have testified about the original autopsy, but the autopsy was inaccurate. That's what you, the engineer, is saying about the forensic pathologist's work. Just gonna highlight that question because that's a pretty great question. He says, and anytime you issue as many revisions as there are to this autopsy, there's no question it's inaccurate. It's just a question of, so you're saying a description of the autopsy is inaccurate. You have no way of knowing if the autopsy itself was performed inaccurately, do you? I guess if I understand your question, could it be possible that the autopsy was performed correctly and yet these erroneous descriptions make it into the autopsy? Well, that was not my question. Okay, then I did not understand your question. What is an autopsy, Dr. McCarthy? Do you know? An examination as to cause of death. And what do autopsy surgeons do in the course of an autopsy? They look for what they believe caused the death. And you think that's all they do? Oh no, they do a lot of things, but that's the ultimate goal of an autopsy. That's the ultimate goal. Yes. So they look, don't they? Also probe and dissect and cut open and examine, or don't you know that? Well, they do all of those things, but I think that is well encompassed under the term looked. I didn't mean to say they put their hands behind their back and walked around visually only. So, are you suggesting that Dr. Golden did not properly dissect or probe or open up these wounds or examine the internal structures or look properly at the wound paths of various projectiles? I'm not sure I'm the one to comment on what is an adequate standard of care in an autopsy, given the volume of an autopsy in this office. Thank you. I'll accept that. So basically, he's backtracking and he never should have said that the autopsy was inaccurate. And so now he's she's backed him into a corner and he's saying, "Oh, no, no, no. I'm not an expert on autopsies." So, great. She moves on and says, "Could I have the diagrams back?" You think the standard of care for an autopsy depends on the volume or depends on what's acceptable in the reasonably acceptable in the medical community? I think there has got to be a balancing of both. In other words, obviously, with the volume, they would have to have a vastly expanded staff to do a detailed autopsy and photograph all the wounds of each and every person they autopsied. But again, you're asking, this is out of my area. It's just that I move to strike the answer, Your Honor, as outside of his area, beyond his knowledge, and pure speculation. Court says, well, except that you asked the question and now you're asking him not to answer it. Miss Abramson says he said he doesn't know. So if he doesn't know, that should be his answer. The court says the answer will stand. Miss Abramson says, on the diagrams that failure analysis prepared, the one I showed, that I just showed you, do not contain Dr. Golden's numbering system. They contain yours, correct? I prepared a diagram with his numbering system and then one with my shot system. So the one I just showed you, do you remember which one it is? No, I'm sorry, I wasn't looking at it for that. So showing you 311 and 312 again, whose numbering system is on the ones I just gave you? Yeah, these are mapped to our numbers. Thank you. And were these ever made in large form, by the way? Were they ever made up as big boards? Did you see that? Certainly, we never did. I could have projected them for you. Did you ever see them made up by anybody else in large form? Not to my knowledge. All right. Showing you now the one that's marked 312, which is Mary Menendez. There's a red circle with that figure on the right arm around the number 1E. Do you see that? Yes. And what is that 1E pointing to? Trying to capture a discussion of this wound area. Let's, this is not a narrative. This is a picture, correct? Yes. And is that picture you are ascribing as part of shot one, that component, 1E, are you not? No. We're showing that the coroner ascribed that wound, or at least raised the potential of that wound being associated. So we labeled it that way. Well, he didn't label it 1E or 1 anything else, did he? That's correct. But in the text, he's not certain. He talks about those being potentially associated. So in our numbering system, we just attempted to number his on, these are his. We just attempted to tie them together. Yes. He didn't relate those shots, which are his left forearm to Mrs. Menendez's right arm, did he? He did not. But you've labeled Mr. Menendez's right arm 1C, correct? Correct. He didn't relate the forearm wound to her to Mr. Menendez's left chest, but you've labeled that 1B, correct? No, no, no. I was too quick the last time. Previously, If he would just answer, it calls for a yes or no. The court says no, he wants to clarify his answer and the previous answer. He can do that. I hate this judge. The witness says the wound 1C, he previously characterized the bottom as an exit and the bottom as an entrance and the top as an exit. Then he has changed now to the top of 1C as not related to the bottom of 1C. I was merely trying to tie his shot patterns on his diagram to my shot sequence. Yes, that's my point. All the ones on this are what you have related to shot 1, your shot sequence 1, correct? This is your relationship. Not quite. It's a hybrid of my relationship and his relationship. 1E is one that he associated. As I indicated to you, he associated it with the left breast and indicated there might be a possible relationship. With what? With the left breast. Yes. He did not associate it with any wound whatsoever on Mr. Menendez's body, did he? Is that correct? Correct. And all of these wounds that you charted on your illustrations as 1 are indicated on these two charts as having a 1 designation, 1A, B, C, D, and 1E, correct? They all carry a 1 designation, correct? And the forearm of this chart carries the designation 1E, correct? Correct. And Mr. Menendez's right chest in the area where the pellet in the sternal zone was located is labeled on this chart as 1B. No, you can see the sternum is not where the arrow is. It's not on the sternum, it's the sternal area. I thought the autopsy indicated he recovered the pellet from the sternum. Am I wrong on that? Dr. McCarthy, may I have your attention? This is 295A. You recall I showed you a photograph that had a circle from the previous trial around the dark spot that I'm pointing to here. Oh, I'd have to see a photograph again of one of those spots. Yes. What? She asked, do you remember? He says, oh, I'd have to see it again? But yes, I remember it. Like what? Okay. Well, what is it if this is not supposed to label the pellet in the sternum? What is it that 1B in this diagram is supposed to show? These abrasions that he associated. And you don't associate? He associated them with wound number 3 of the right arm, correct? Yes, the 2 or 3. And you're associating them directly with his wound number 4, the left arm. You're saying they're coming left to right. He said it came right to left, correct? Hold on. There was too much in that question. Hold on. I'll withdraw the question, Your Honor. Dr. McCarthy, were Mr. and Mrs. Menendez shot with green rods? No. What were they shot with? 10 shots of number 4 buckshot and 2 shots of birdshot. Now that's your opinion. That's 12 shots, correct? Correct. But in any event, however many, they are shot with multiple pellet-loaded ammunition, correct? Yes. Not a solid green rod, right? Correct. Which must be what they're using in the images to show the angle and whatnot, the entry wounds. And when you show on these illustrations of yours a solid rod, oh, so it's on his illustrations, the rods. So when you show on these illustrations of yours a solid rod, you have testified that's just representative of the general geometry of the trajectories here. Is that correct? The direction of the shot, correct. And when you showed in your shot 1A, Mr. Menendez with his arm raised in such a position that visually it appeared it was quite close to the armrest of the couch, and you showed a green rod, you weren't trying to show one pellet going through, were you? The rod represents the direction of the epicenter of the shot. It's not necessarily representative of the geometry of the shot pattern. And you've indicated, have you not, that The shot into the left elbow shows a scattered pattern, correct? Yes. And you're unwilling to discuss distance, correct? Unwilling to defend a particular distance for reasons I've discussed. It could encompass a wider range. And so when we showed artistically, using the same rod symbolically, that a spread shot pattern the way that you have depicted, I don't find any of the clips now, in the position you chose to illustrate, did you not understand that these photographs showing the green rod hitting the channel changer, the remote, to also be representative of what a spread shot pattern could do if the arm was in the position in the illustration? I do not understand that rod, your artist, then would have had to expand that rod dramatically to give a fair representation of how big it would have to be at the elbow position to start to strike the channel charger. You purposely just used, I don't know what was saying, your artist would then have to expand that rod. I don't know what he means by that. And that kind of threw her off too. She's like, you don't give my artist, like, what are you talking about? You purposely just used a green rod rather than scatter of shot. Because if you had shown scatter of shot wide enough to cause the pattern, it would have hit not just the channel charger, but the armrest. Isn't that true? No, there's no requirement for that whatsoever. Are you aware of any pellet tears in the armrest? I'm unaware of any. So he wasn't sitting there when he got shot. His arm wasn't in that location when he got shot. That's proof right there. Are you aware of any pellet tears in the other side of the couch, the inside part of that armrest? I'm unaware of any there. Now, you talked about with Mr. Khan what you meant in the notations that you wrote on that article that you and some others were writing for a journal. Yes. And do you believe, Dr. McCarthy, that anything that impeaches you proves that you're wrong is, quote, confusion of a jury? If I'm right and it confuses the jury, yes, I mean, it's clearly confusing. If I'm truly wrong, you do take the position that anything you testify to, you're right about, don't you? The overwhelming majority, but I can't say every single thing. I mean, everybody is mortal. As you've told us, you get paid a great deal of money to testify on behalf of large corporations, don't you? You mean in other environments? Yeah. And it isn't good for your business if you are shown to be wrong as you testify, is it? Oh, obviously. Not in my business. It is not good business or good professional conduct to make a mistake. What you're doing in those notes to an article is the notes about being confusing is you're asking someone to change the examples that they have chosen to show because those examples, if published, could contradict you as a witness. Isn't that what those notes mean? Oh, no. What they mean is that someone could take the chart and, without understanding the background, the 22 pages of academic discussion around it, could say, didn't you say X here and Y here? And, of course, the answer is no. But as much as possible, and I don't always succeed, but as much as possible, I'd like to keep the opportunity to make such a superficial cross examination down to a minimum. Word salad. So you don't like to be contradicted in cross examination? Isn't that it? That doesn't bother me. What bothers me is when someone attempts to use an example to confuse a jury on a scientific point when they don't know the correct answer. Sort of like when someone that's completely outside his area of expertise offers opinions in contravention to the experts who have otherwise looked at the same evidence. Is that what you mean? No, it's the difference. Well, Dr. McCarthy, Mr. Khan says, may the witness explain his answer, Your Honor? Court says yes. The witness says, it is the difference between intentionally taking an example where you know what the correct analysis is and trying to convince someone of the opposite. In this particular case, Miss Abramson says, I think, Your Honor, he's gone beyond explaining his answer. The court says, no, he's still answering. Of course. Oh, this judge is very pro prosecution. The witness says, in this particular case, I have been forthcoming as to my expertise and testified to the best of my ability to use it to reconstruct this particular crime scene. How are you on counting? Are you an expert in counting up to 10? Questions are awesome. I usually can do that error free, yes. Can you explain, therefore, why you counted, in spite of Dr. Lawrence's testimony and the showing of the x ray to the jury, why it is you chose to include in your pellet count for shot one only 8 pellets in Mr. Menendez's right arm when previously it was established there are 9? I guess I'm less comfortable with previously it was established. A lot of these x-ray indications are not as clean and opaque and starkly dark. And also on some it's questionable whether it's a full pellet or a partial pellet. That's why counting a pellet in x-rays is not an exact science, and I'm very comfortable with embracing Dr. Lawrence's count. Of 9? Of 27. No, he didn't count 27. He counted 9 in the right arm. Are you embracing that count? I'm comfortable with the sequence that he counted. Now, we will have to go back over his specific testimony to find where he counted what by x ray. Will we? I mean, I would. Objection, argumentative, motion to strike. Objection sustained, the question and answers stricken. Because it's not up to him what they talk about on cross examination. She gets to ask the questions and he continues to try to lead, and it's entertaining at this point, and I'm here for it. I'd be eating popcorn if I wasn't reading. So Ms. Abramson says, you have admitted you have no medical training in reading x-rays whatsoever, correct? Several times. And Dr. Lawrence has, correct? That is my understanding, yes. And you no longer remember that he counted 9 in the right arm of Mr. Menendez. Shall I get the chart? Yes, I believe he counted 9 on 9 x ray. And he counted 5 in the left elbow, correct? 11 x ray. Is that yes? He counted 5 in 11 x ray. Well, I don't want to talk about x rays. I want to talk about parts of people. Then just a moment, please. He counted 5 on the left arm. Left elbow of Mr. Menendez? Yes. And then you counted 13 in Mrs. Menendez's chest based on what? 3 x ray? 3 x ray. And you counted how many in her left forearm? I attributed the possibility of one there. And what finally did you decide to do about the one in her left elbow area farther up? Just ignore it? Frankly, I'm uncertain as a precise matter about either of them, but I counted 1. So you're only counting 1. That's correct. So, and you're not counting the pellet in his chest? No. That clearly, directionally, that doesn't appear to be connected to the shot. So why don't we just add what you've now said you are counting? 9, 5, 13, and 1. Well, not quite. You're trying to add up what I'm counting, and Dr. Lawrence counted. When I counted 9 x-ray, I attributed 8. Are you again refusing to accept the count of a doctor who is trained to properly read x-rays? No, Ms. Abramson, but you want to take my count on some and you want to take his count on others. I have no trouble with a consistent interpretation of all the x-rays. If you do that, we both can't come to 27. Wow, this guy. Okay. Dr. McCarthy, what's there is there. However, you may choose to add or ignore. There are 9 pellets in that x-ray of his right arm. Do you dispute that? Objection, argumentative. Rephrase the question. Do you dispute that there are 9 pellets in his right arm? My count was 8. We can put it up and show the disputed pellet. Why don't we do this? Did you ever bother to count how many holes were in her breast? which is your backstop terminal point. I counted the defects at various times, but obviously, because of pellet fragments, your defect count may not match your pellet count. So you don't have any idea if there are pellet fragments or whole pellets, do you? Oh, most certainly we do. Look at the chest x-ray. Well, isn't it true that there are 16 separate holes in her breast? I would have to blow that up if you want an independent count for me. So is that you don't know? Not from memory, that's correct. Now, you talked about Exhibit 309, which is a photograph that you then blew up of Mr. Menendez's body on a piece of plastic with the skirt pulled up to demonstrate bleeding after the coroner's investigators removed the body. Is that right? No. You asked me about dripping blood, and I explained to you that my recollection was there was blood drips when the bodies were moved. And sure enough, there are blood drips on that plastic. There was one drop of blood that you pointed to on that plastic. That is correct. I think there are four, and I think a reasonable, perhaps unopposed interpretation is that there's others. Your Honor, I'm going to object to anything after four as non-responsive. All right, objection is sustained. The rest is stricken. And do you believe we were talking about drops of blood on the carpet when you remarked in cross-examination that the bodies were still bleeding? Do you recall that? No, my recollection is you were asking about the potential of drips of blood on the couch, and I indicated to you that my recollection was that the bodies were dripping when they were removed, and that's when I showed you the drops on the plastic. Now is that going to be your explanation for drops of blood on the carpet to the west of Mr. Menendez as well, that they first moved the body onto the carpet so it could drop there and then put it on the plastic? I'm sorry, without knowing what specific drops you're referring to, I can't hazard you an explanation with the understanding that blood spatters are not my area of expertise. We're talking about drops. You know there's a difference between a drop and a splatter. I know there's a difference that you would let me interpret a particular picture unfettered in that regard is really the question I have. Miss Abramson says, may I strike the witness's question since he's not supposed to be asking questions? The court says no. That was his explanation of his answer. Overruled. Wow. It's tough, man. When your judge is against you, it's really tough to get anything done. It's like in the Karen Reed case, everything was a battle because Judge Canoni just did not like Karen or her defense or something, whatever it was. She just had an extreme bias. This judge is not nearly as bad, but it's still like palpable. You can sense it between the two. And this is just written pages. This isn't even and that wasn't even bad. I'm talking like sometimes it gets a little more heated with her and the judge. They really did in the first trial. We haven't seen it so much yet, but once we get into the defense's side, I bet you we will. All right, moving on. Miss Abramson says, so in 309 is the photograph that you're relying on, and there does show, does it not, his shirt moved up 309. It's not on the chart you're looking at. Oh, I'm sorry. I can't do the exhibit number from memory. I'm sorry, ma'am. Well, you have the photograph from memory. It's what you have in mind. It's the body on its side of plastic. The court says, let's show him the photograph if that's what you're talking about or what you're asking about. Ms. Davidson says, it's this photograph. He says, yes. Would you circle the four drops and not smears, drops on that photograph? Sure, I've circled them in red. And in that photograph, is the shirt pulled up? Yes, ma'am. And do you know if the blood came from the process of pulling up the shirt or not? Do you know that? Obviously, I don't know. It seems like an. Your Honor, he answered the question. That's correct. The answer is in. Next question, please. Thank you. Now, Dr. McCarthy, concerning the ammunition that you purchased, did you purchase that directly from Italy? No, I bought it from my recollection, first of all, I did not buy it directly from Italy. I bought it from a US wholesaler. And how many of those shells did you open and count? Until very recently, only a couple. When is very recently? I opened it up, I think, two or three originally, and I opened up 10 more this weekend. Didn't you testify originally on direct that you had found at least two with a count of 26 and at least one with a count of 28? Not in the Fiachi ammunition, no. Not in the Fiachi ammunition? No. That was a more modern, as you properly observed, cup-filled design. No, no, no. We're talking about ammunition that you ordered a case of. Yes, that's Fiachi ammunition, correct? And that's what I'm asking you about. You testified that you opened up the only ammunition of this type that you had and found numerous ones with counts of only 26 and found at least one or more with counts of 28. Isn't that what you testified to? No, I didn't relate that counting to the Fiachi ammunition that I had purchased from my testing. Well, what counting did you relate that to? It was the Winchester ammunition that we had opened previously of an older design using the overwad as opposed to the cup. And how many of that's where you opened two or three? We opened 10 of those. No, no, I'm talking about what did you before you testified on direct examination in this trial? I only opened two or three of the Fiachi. Yes, you opened up two or three of the Fiachi. That's all you opened? Correct. And of that two or three that you opened up, how many were off count? Oh, they were all 27. So it was some other ammunition that you were testifying about when you said they were off count. Yes. Kind filled of the older technology, these new shells that I have are still everything after yes, I would ask to be stricken. Sustained, the rest of the answer is stricken. The witness says, I'm sorry. Yes. Now, did you attempt, since obviously you were doing some experimenting this weekend, did you attempt to obtain the exact, strike that, did you attempt to obtain Fiachi number 4 buckshot packed exactly the same way that the ammunition that was used in this case was packed for experimentation? No. And why didn't you try to get the real stuff? Well, when I found out the disagreement between what I had and what was used, there was no sense going through the effort of finding the real stuff unless the shooting exercise was going to prove out to be reliable. That is, if the more advanced Fiachi ammunition that I was shooting didn't produce a repeatable group, then the real stuff would only be predicted to produce a less repeatable group. How about for the purpose of count? I didn't base any of my reconstruction on count. I didn't count Winchester over the weekend. I counted Fiachi over the weekend. Why didn't you open up new Winchester over the weekend packed in the old-fashioned way? No, 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 I'm sorry. I think there's confusion. This weekend, I opened up some of the new Fiachi. Originally, the testimony that I was talking about is Winchester we had opened previously. So you opened up your new Fiachi, which are still the wrong ammunition, correct? Yes, it's what I got. The gun's not near the witness, Your Honor. At least, I don't think it is. The witness says it is not. Miss Abrams says this red box, maroon or purple, actually, is one of the cases that you purchased, correct? Correct. Now you testified that your understanding was that Fiachi number 4 was sold by weight. Well, it is. It's on the box. Fiachi number 4 is sold by weight? Yes. And it is your testimony that all Fiachi number 4 is sold by weight. Oh, no. Why is this sold by weight and not some other? You'd have to ask Fiachi. What about ammunition that was used here? I haven't testified about the ammunition used here outside of what I've been asked. I'm asking you, is it sold by weight? I don't know. Why don't you know? Didn't plan any part in my reconstruction. I've always used 27. So you don't know because you've never, to this minute, you've never tried to get the real ammunition to compare it to anything in this case, correct? I tried to get the real ammunition, otherwise I wouldn't have had to order Fiaggi or called the Fiaggi factory. And you couldn't find it anywhere? I could not find it anywhere, that's correct. Now, Deputy Oland, I'd like to mark this bag and its contents next in order. The court says 313. Miss Abramson says, would you carefully remove the box that's in that bag, Dr. McCarthy? And he does so. What is that? It's a box. Appears to be 10 shotgun shells from Fiaggi of America. Number 4? Number 4 buck. Sold by pellet count. Yes. 27 pellets. Number 4 buck. And would you open the side of that box and remove one of those rounds? Surely. And can you observe the packaging of that round? Yes, it's a translucent case. And does that appear to be the identical kind of packaging as used in the ammunition in this case? It looks familiar. I wouldn't testify to identity until I dissected it or whatever. And if I were to tell you that ammunition was purchased this past Friday right here in Los Angeles County, would that indicate to you it ain't that hard to find? No, I know how hard it is to find, but you found a box of it. My congratulations. We found a case of it. Oh, good. And you see, I just removed a piece of paper from inside this bag. Uh-huh. Is that a receipt dated November 17th, 1995? It is. Indicating a purchase for the amount shown on the little price label on this box of ammunition. Indeed, it is. $5.95 plus tax. Uh-huh. I'd like to mark the two components, parts of 313, the box of ammunition and the shells, as 313A and the receipt as 313B. Court says, all right. Abramson says, and replace them in the bag. I have nothing further. Court says, any redirect? Mr. Khan says, no further questions, Your Honor. The court says, okay, thank you. You may step down. You are excused. The witness says, thank you. Court says, we will take a short recess. Don't discuss this matter with anyone. Don't form any final opinions. We'll resume at 10:30. The following proceedings were then held in court outside the presence of the jury. So we've got some legal arguments here. All right, so the court says everyone is present without the jury. Are there any further witnesses by the prosecution? Mr. Khan says, yes, Your Honor, we'd like to call Detective Zoeller just for a couple of minutes and then we'll be resting after that. The court says, all right, and then other than discussion of exhibits, which can be deferred to a time more convenient to deal with matters outside the presence of the jury, will there be any motions before the defense begins? Mr. Gessler says there would be the 118.1 that I mentioned as to the lying in wait, Your Honor. But I believe we also agreed that could wait. We could easily decide that the state of the evidence is after what the state of the evidence is after the people rested for that motion. The court says, all right, if there could be a stipulation to that effect, that the defense may bring its motion under 1118.1 sometime in the future before the defense rests its case if they choose to do so, with a stipulation that it had been brought at the time the people closed their presentation of evidence. Mr. Khan says, yes, Your Honor. Court says, is that agreed? Mr. Gessler says, so stipulated, Your Honor. Ms. Abramson says, so stipulated. The court says, all right, let's have the jury out. The jury enters the courtroom and the following proceedings were held. The judge says, okay, the jury is back and we're about to resume. It's a little cool in the courtroom and I've asked if they can adjust the air conditioning and it's sometimes done here in the courtroom. They have some technician come in and adjust things. Sometimes they do it by remote sensor devices that they have in another building. I don't know which will be done and whether it will be done, but we're trying anyways. All right, the people may call their next witness. And Mr. Khan says, yes, the people call Detective Zoeller at this time. All right, so Zoller's recalled. The court says, state your name again for the record. He does so. The court reminds him he's still under oath. Direct examination begins. Mr. Khan says, Detective Zoller, I'd like to show you the photograph that has previously been marked as 309 for identification. Do you recognize that photograph? Yes, I do. And can you tell us what that photograph depicts? It depicts Jose Menendez lying on the floor on a plastic tarp that the coroner brought. Can you tell us when it was that that photograph was taken? Photograph was taken immediately after the coroner placed him there, the morning of the 21st of August, 1989. And you previously described that during the movement process that the victim's brain fell from his head. Is that correct? That's correct. And can you tell us what it is that we're looking at over here in the upper right-hand corner of the photograph? That appears to be his brain. During this movement process, did you see any dripping of blood? Yes. Can you can you describe for us what you observed at that time? Once Jose Menendez was picked up by the coroner's investigator, and the coroner's investigator or helper, as soon as he was tilted with his head back, there was dripping from the head wound. Can you tell us where he was physically when that dripping actually began? Well, they picked him up at the couch and then put him pretty much sideways and then carried him over to the plastic, which is on the floor. I have another photograph which I would like to show you that has previously been marked 307 for identification. Can you tell us what that depicts here? This is the photograph of the wooden floor directly inside the den from the double doors and the edge of the carpet. Okay, and I would like to direct your attention specifically to the dark mark which appears at the bottom of the photograph there. The dark mark which Dr. McCarthy previously numbered number 1 as he was testifying in regard to that photograph. Do you recall seeing that as at the crime scene at the time of your investigation? Yes. Can you tell us what it was that you observed here? It was a piece of reddish colored body matter. Okay, do you have another photograph with you today? Yes. That shows that from a different view? Yes, I do. Before you do that, let me show it to counsel. Mr. Khan, I have another photograph, or Mr. Khan says, I have another photograph. Your Honor, I would like to mark as 315 for identification. It's a photograph. The court says, I think we're at 14. Yes, I'm sorry, 314. Thank you. Showing you 314. Can you tell us what that photograph consists of? It's another angle of the entryway, and within the shadow of the door, the white door, you can see the matter that I'm describing that's on the parquet floor. Okay, thank you. I have no further questions at this time, Your Honor. Court says cross-examination. Oh, I was supposed to be paused. Whoops. Didn't pause. All right, sorry about that. So Ms. Abramson is doing the cross for Erik. She says, for doing the cross of Detective Zoeller for Erik's team, I should say. She asks, what time was it when the people from the coroner's office came to the scene? Approximately 2:30, 3 o'clock. 2:33 in the morning? That's correct. And during the time that they were there, well, did they immediately remove the bodies or did they wait until certain other things had been done? They waited. It wasn't immediate, no. And during the time that they were waiting, were photographs still being taken at the scene? Yes. And calling your attention, in fact, to the board 1A that's down below, it's 295. And specifically calling your attention to photograph G, which is the last one in the center line, is that a portion of Jose Menendez's body on the plastic sheeting? Yes. Now, you've worked with the coroner's investigators before, have you not, Detective Zoeller? Yes, I have. And you were still there supervising this crime to make sure that, supervising the crime scene to make sure that it wasn't tampered with, were you not? That's correct. Don't they attempt to not tamper with the physical evidence while they're doing what they have to do to remove the bodies? To the best of their ability, that's correct. Sometimes they even ask beforehand what we've done at an immediate crime scene to know whether they are disturbing anything or not. All right. And with respect to the bodies, a whole series of photographs were taken of various parts of the bodies when the coroner's investigators were there to preserve them in that condition, correct? Correct. To preserve the observations that one could make of these various parts of the bodies right there at the scene. At what point? When the coroner's investigators were there and the photographs were being taken. For the most part, yes. Well, take a look, if you will, on the same chart, 295, photograph C. The third one down on the left-hand side is a photograph, is it not, of Mrs. Menendez exposing the brassiere that she was wearing. That's correct. That was taken at the scene. That's correct. And there's a rubber gloved hand or partially gloved hand that's lifting up her shirt for the photograph, correct? Correct. Is that a coroner's investigator? Yes, it is. And is it your understanding that by doing that and having a photograph taken, he was trying to present this information, whatever information's contained in that view at that time? Yes. And with respect to photograph G, the bottom one in the middle, that's a photograph of Mrs. Menendez's left arm, correct? That's correct. And he's on that sheet of plastic that you talked about. Correct. Is that the same sheet of plastic? Yes, it is. And that sheet of plastic, when the body's on that sheet of plastic, it appears that his shirt is still ending somewhere down over his pants in the waist area. That's correct. The photograph that you were shown before, 309, the shirt's been lifted up at that point, has it not? Yes, it has. And other things are being shown in the photograph with the shirt lifted up that couldn't be seen with the shirt down? That's correct. Now you indicate there were two people from the coroner's office who moved the bodies. I believe so, yes. And where in the room is Mr. Menendez's body at the time when they're taking photograph G? Directly in front of the couch, I believe, also in front of the coffee table. And so, am I correct in describing that what the coroner's investigators did was they put down the plastic, lifted the body off the couch, and put the body on to the plastic? Correct. They didn't put the body down on the carpet first and then slip the plastic underneath it? No, they didn't. And when they removed the body from the couch, of course, the body was in a seated position at first, correct? That's correct. So did someone come up and lift up under his arms and someone else lift up his feet? I don't recall exactly how they did it. But somehow they lifted him off the couch and they reclined him onto the plastic. Yes. And the minute he hit the plastic, you saw, because of this very large head wound, you saw things coming out of that wound. That's correct. Now, Detective Zoeller, with respect to the other photograph that I've now buried, unfortunately, that you showed us yesterday, the small one, number 314, is another view of this red stuff that you've called matter that's on the wooden parquet area just before the foyer, correct? That's correct. Did you collect that matter? No. To find out what matter it is? No. No tissue was collected from the scene, correct? That is correct. They did not collect any kind of tissue, didn't do any blood samples, nothing. Kind of important if you're recreating the scene, you might want to know. He says, or she asks, no blood was sampled from the scene. And that's correct. None of the spatter patterns were attempted to be matched by either or to either of the two decedents, correct? Correct. By sampling the blood and testing it and finding out whose blood it is, that's correct. We all now know that people have different blood. Yes, we do. And there are ways to determine whether the blood belongs to one person or another in a scene. That's correct. And there were photographs taken of the couch area and the carpet area before the coroner's investigators moved the body, correct? That's correct. And then there were some photographs taken after. Yes. Fewer were taken after, correct? Yes. And if hypothetically a photograph shows an object before the body was removed and shows that same object in that same position after the body was removed, is it fair to say that object was not disturbed during the removal process? Yes. Did you note, Detective Zoeller, that there was what appears to be brain matter on the couch cushion next to Mr. Menendez? Yes. And that brain matter appears in photographs when when the body of Mr. Menendez is in place, correct? That's correct. And it also appears in exactly the same place when the body is removed. Yes. So it didn't fall out when he was being moved, sorry. So there's brain matter on the couch cushion, basically where they're saying Kitty would have been sitting at the time of the shooting anyway, so how did it get underneath her? So it couldn't have, and it didn't fall out when they moved his body. So she's making some good points here. And he says, and that's adjacent to the evidence item number 6. Yes. And isn't it true, Detective Zoeller, that that brain matter is precisely in the place where Dr. McCarthy shows Mrs. Menendez would have been sitting, if I could talk, sitting in his reconstruction of shot number 4, the shot to Mrs. Menendez's head. I don't recall how far away from Mr. Menendez the brain matter is and how close he has put Mrs. Menendez to the body, to him, next to him. I can't talk. Oh my God, I've been talking too long. My tongue just stops working. So yeah, he says he doesn't remember. Sorry. Okay, but is it on that cushion right next to the cushion that Mrs. Menendez or that Mr. Menendez is sitting on? He says yes. Nothing further. Any redirect? Yes, Mr. Khan says. And he asks, do you recall if the body of Jose Menendez was placed on plastic before the body of Mrs. Menendez? I believe it was, yes. And I would like you to tell us, as precisely as you can, exactly where the plastic was placed that the body of Jose Menendez was placed on. From what I recall, it was placed in front of the coffee table, pretty much in the center of the room, between the couch and the television. So, to your recollection, did the coffee table remain in place while the body of of Jose Menendez was taken from the sofa and placed on that plastic? Yes. And during that time, do you know whether any drops of blood fell on or near the sofa? I don't know precisely. No. There was an opportunity for drops of blood to fall on or near the sofa at that time? Yes. And that piece of body matter that you've noted here on the floor near the entryway, was that there before the arrival of the coroner's office? Yes. Thank you. I have nothing further. Court says anything else? Miss Abramson says no. The court says thank you. You may step down. Any further witnesses to be offered by the prosecution? Mr. Khan says no, Your Honor. Subject to the receipts of the exhibits, the people rest at this time. The court says all right, the people rest. Is the defense ready to proceed with witnesses? Miss Abramson says yes, and her first witness is going to be Dr. Martin Fackler, which we will get into in tomorrow's episode. Thank you guys so much for watching. Let me know what you guys think. Be sure to hit the like, subscribe, comment, do all the YouTube things, and I will see you guys in the next one. Take care. Bye now.